Good morning. This is a welcome video. I'm welcoming all of you to Justice 261. And I'd also like it to be a little bit of an introduction, not only to me, but also to our first learning module, which we begin officially tomorrow morning. Today's Sunday, the 20th of September. What we're going to be doing in this course is learning about how the judicial system administers itself, how it is organized from the lowest level trial courts up to the U.S. Supreme Court. And in this first learning module, what you're going to be dealing with is the distinction between the state court system, which has its very own system of judicial administration, and the federal court system, an entirely separate set of courts. Sorry, that was doesn't matter. The state court systems generally begin at the lowest local level with what are called small claims courts or district courts or county courts or township courts. They're called by many different names in each state. In your own state, you'll be able to, you'll be required, in fact, to research the system and find out what those courts are named. But in general, most states have courts that are called courts not of record. And what that means literally is that there is no permanent record kept of the proceedings in those courts. There's no jury, there's no court reporter, etc. It's very relatively informal proceeding just in front of a judge, and matters are disposed of right there and then in the court. Sometimes these are misdemeanor criminal matters, sometimes they are civil matters, sometimes they're juvenile matters, sometimes they're what used to be called domestic relations matters and now are generally grouped under the heading of family courts. Anyway, you'll get into that yourselves as you explore your own state's court system. But we're not really concerned with those courts as much as we are with the lowest level of what are called courts of record, and that means exactly what it says. It means that the court keeps a record of its proceedings, either or usually both through the device of a court reporter who transcribes all of the proceedings in front of the court, and also then by written orders of the judge that are preserved, and by through things like published court reports. So we have a lowest level trial court. We have usually, not always, depending on the state, an intermediate appeals court. And an appeal means that the dissatisfied party, or the losing party at the trial level, has decided to ask a slightly higher court to review what the trial court did and to determine whether any mistakes in law, not mistakes of fact, but mistakes in law were made. If that next level, the intermediate level appeals court, decides that the trial court made some errors, then the appeals court can reverse the decision of the trial court and do one of two things: either order that the party who lost at the trial level now wins, or send the case back down to the trial level for a new trial. Now, sometimes the person who who loses at the appeals level is also dissatisfied enough to want to have an even higher court review the decision. And that usually is an option at the state in the state court system, because most states, not all again, but most states have a trial level, an intermediate appeals level, and then a highest level. And those, I'm not even going to give you their names because the names vary so much from one state to the other. I can tell you what the names are in Virginia, which is where I am. The lowest level of the trial level court of record is called the Circuit Court. The intermediate court is the Virginia Court of Appeals, and the highest court is the Virginia Supreme Court. That's just Virginia. Those names will change radically from one state to another. And what I want you to do, among other things, in this first module is tell me what they are named in your state. Now, We shift to the federal system, which is not above the state system. It's just separate. The only part of the federal court system that can really be called above the state court systems is the U.S. Supreme Court, because it's above all other courts in the United States. Now, the federal court system is organized also on this tri-level hierarchy. The lowest courts for our purposes are the U.S. district courts. The intermediate courts are called the courts of appeal. They used to be called the circuit courts of appeal, and people my age and older still call them that. And the highest level is the United States Supreme Court. Again, they operate very much like the state courts. The district courts hold trials in front of a jury or in front of just the judge, depending on several factors that we'll get into as the course goes on. The next level is the Court of Appeals, which does not hear cases in front of a jury. It just reviews what has happened at the trial court level. And then there's the United States Supreme Court, which is the only court in the United States that can select its own docket. It doesn't have to hear a case if it doesn't want to. It doesn't have to give reasons for not hearing a case. It simply refuses to hear it. When it does hear a case, as we'll get into as the case goes on, it usually is for one of several reasons. One is that the case has some kind of national legal significance or constitutional significance. Another is that there's some conflict among the various circuits in the United States. Maybe the 12th Circuit is saying one thing on an issue of law, the 4th Circuit saying something different, the 7th Circuit saying something different, and the U.S. Supreme Court at some point, not immediately, will jump in and resolve all those differences among the circuits. Now, I've given you a preview, and I'm going to post this video in an announcement, a welcome announcement in the announcement sections, and in that same announcement, I'm going to give you some attachments that show you a depiction of the structure of the federal court system and of a typical state court system. Now, the state court system is going to be a little bit vague because it's typical, and it's not really representative of any particular state. Keep in mind, as we go through this course, that we are dealing with two entirely separate state court systems. Actually, we're dealing with 51 entirely separate state court systems. We're dealing with the federal court system, and we're dealing with 50 different state court systems. So we're not going to, obviously, this would be a much longer course if we were actually going to go into detail on all of those 51 systems. We are not. We are going to talk in generalities until we get to the final project. I would like for you to pay particular attention to these videos that I post. I may not post, I may not post a video every week, but I will post a lot of videos. And when I do, I'm going to be trying to help you out with that final project. It's not easy. I'm going to tell you right up front, it's not an easy project. Start reading it right now. Ask me any questions you might have about the terminology used in the project. Ask me any questions you might have about what is expected of you as we go along. Keep asking me questions. The best way to do that is by email or by a post in the general discussion board. I will answer you as quickly as I possibly can. I try to do it the same day, even within a couple of hours of when you post it. So depending on what I'm doing on a particular day, I'll get back to you as soon as I possibly can. That's my job. It's my pleasure. I can't wait to hear more from all of you and get to know you a little bit. So I'll say goodbye for now. This video has run longer than I usually do. I try to keep the videos under 6 or 7 minutes. This one's over 9. I'm talking too much. So I'm going to say goodbye. Bye. And I'll see you later.